There you go. Yeah.
Okay, so this presentation is called Manslaughter is Manslaughter, where I'll be exploring some legislation across various jurisdictions that I believe to be somewhat false and therefore need to be corrected through my proposed solution. So to open up this discussion about murder, I'd like to talk about this. It's an old movie, but it's based on a real case, but I think it really gets down into the grit of what murder is. So in this case, Coleman Peterson, his wife was raped, and it was premeditated. In retribution, he goes and kills the individual. However, in the Michigan Supreme Court found that they found this old case back in history, he had irresistible impulse. So not only was he not found to be guilty of first-degree murder, but he was entirely innocent. The ironic thing is that he wasn't even a good guy. He never even paid his lawyer fees. He just left town. But the point is that murder is very nuanced, and sometimes, good people can do bad things and bad people can do good things, but murder should not be automatically first degree, automatically second degree, or automatically innocent. To even build this deeper, kind of where my sort of passion is in terms of literature and philosophy, I bring this to Dostoevsky's two great masterpieces. Firstly, Crime and Punishment, in which the first case, the protagonist actually does go and kill a woman with an axe and another bystander. However, in his later book, his eldest character, Dmitry Karamazov, is an innocent individual. But nonetheless, in the older book, Crime and Punishment, the guilty individual of first-degree murder lives a happy ending and turns out to be quite a good person, whereas the other guy, Dmitry, who is actually innocent, is sentenced to death. So the point is, good people can do bad things and good people can do good things, but the law should be nuanced, and that's why we have a jury, which is very, very important. Murder is a heavily complex crime, and therefore laws must maintain flexible. So the problem here is in multiple jurisdictions. We'll start in Canada, New York, Hawaii, and Iowa. Killing a police officer is automatically punished as first-degree murder. So in the Canadian Criminal Code, irrespective of whether a murder is planned and deliberate on the part of any person, murder is first-degree murder when the victim is a police officer. In New York, this is from Cornell Law, possibly an observance of confusion over premeditation, has abandoned premeditation altogether as the test for first-degree murder. Instead, New York defines first-degree murder as killing a police officer or a trial witness or a terrorist act. Similar, Iowa uses a combination of the New York approach. So if you kill a police, it's first-degree murder, but if you premeditate, it's also first-degree. And finally, Hawaii has a similar law in that a law enforcement officer, judge, or prosecutor arising out of the performance of official duties, if you kill them, it is first-degree murder automatically, whether or not it's premeditated or not. So going back into the history of this, firstly, I think we can derive the main body of our common law from the Magna Carta, or the Great Charter, founded in 1215 and signed by King John. Basically, it subjected the monarchs to the laws of the people, and therefore all are equal and before and under the law. But why should this be relevant in the States or perhaps in Canada? In 1776, Thomas Paine, in guiding the American Revolution, wrote the book called Common Sense, where he derives the rights of man from the Bible. For example, Gideon and Samuel in the Matthew 12:21 and 1 Samuel 8, he says, "The Almighty hath entered his protest against monarchical government." So therefore all are equal before and after. And I also think this is quite significant that even the symbol of the law, which is this scale, is by definition supposed to be balanced. So I think it is almost a crime to humanity that police officers in these jurisdictions are treated above. And these are almost kingly privileges, because even a prime minister or a president, you wouldn't automatically call it first-degree murder just by the nature of their profession. So even going back further, so Hopkins-Huget's case of 1666, the King's Army arrested an individual to enlist in the army, but in the process of fighting back, he killed a guy named John Barry. But the common law case determined that the maximum penalty was manslaughter because it was unlawful arrest. The similar was found with Queen v. Tolley, but however, the difference was in this case it wasn't for enlistment, but nonetheless he resisted an unlawful arrest and was not found to have first-degree murder. Later, this was brought to the United States with the Ballard Elk v. United States case, in which an American tribal police officer killed another police officer in South Dakota. However, the charge was reduced from first-degree murder to second-degree or manslaughter for resisting unlawful arrest. However, if this happened in the aforementioned geographies, this would have actually been found as first degree. So, and this has also been continually proven in the Louisiana Supreme Court cases, City of New Orleans v. Leon, and as well White v. Morris. So it's pretty common practice at this point. But as I mentioned, Canada, New York, Iowa, and Hawaii all would find these cases to be first-degree murder and undermine these past common law cases. And I would even argue in certain circumstances, even in temporary insanity, defense should be available. So for example, it's possible that a police officer might rape and kill your wife in the case of the earlier aforementioned case, and in that case you could plead the temporary insanity defense and it should not have been first-degree murder. But nonetheless, to give a balanced argument, here are the arguments why they should get better protection. Firstly, the police officers do take greater risks by nature of their profession, and therefore they necessitate greater protection under the law. Secondly, officers represent a group, and therefore they are subjected to all premeditations towards this group. If you want to kill one cop, you might just go and kill the most convenient cop or the nearest one by, and it wasn't necessarily the latter one's fault. And thirdly, they have special training and education that creates for greater law-abidingness and perhaps prevents them or renders them more worthy of favoritism under the law. However, to break each of these down, firstly, police officers are already armed and armored and trained for more risky situations to account for this. So they already do have more protection under the law in this sense. And ironically, in Canada and New York, where gun laws are even more strict, the police actually have more power already under the law relative to citizens, and they get this greater protection. So it's double wrong there, I would say. In terms of the second case, I think this can be proven wrong because all individuals do represent groups anyways. It would be other professions like politicians, actors, and artists all represent a group too, and even races, genders, and age groups all represent a group, and therefore you cannot make the police officer group more special than other groups. For example, to expand on this, John Lennon was shot, but perhaps you couldn't say there should be a higher value on the life of all rock stars because some have ego problems. Same thing, you wouldn't put like Justin Bieber, he should not have higher protection under the law. However, I do think in some cases murder of a marginalized group could be found premeditated. I think a lot of racial killings can be found to be premeditated if you did kill arbitrarily some minority for a racial reason. That is obviously first degree, but I don't think the de facto case should be that killing a police officer is automatically first degree. And as for the last case, the special training, this implies that they have a heightened status and worth, which actually could be abused and cannot be used as a reason for legal favoritism. I also propose, and this is this cannot be proven, but I propose that higher protection under law would actually incentivize the individual to more likely escalate a situation. I saw this in actually an old movie, but I think it's very true, and I think it's a good measurement of human psychology. It's called Mutiny on the Bounty, but it was based on a true story. The movie's 1962, very old, but nonetheless, because the captain to mutinate a captain was conviction by death. But so in knowing this, the captain actually abused his power and was more likely to escalate the situation. I believe this is definitely true in a closed environment, but I believe on the grand scheme of things, I think if a cop knowingly knows that he has greater protection, he might be more likely the one to push the opposing party. But this is obviously just my guess. But in terms of more relevant examples, for example, rest in peace, Breonna Taylor and George Floyd, who both died this year, March 12th and May 25th, respectively. In terms of Breonna Taylor's case, none of the murderers were charged with murder or death, and the murder of George Floyd Chauvin was only charged with second-degree murder. The strange part was, if the tables were turned, and if either of these people had to, and perhaps maybe even rightfully so, had killed the police officer, they would have actually been charged with first-degree murder, whether or not it was an accident, premeditated, or manslaughter or not. So it's just a complete imbalance, and we're starting to see some negative repercussions from this rhetoric. So what is my solution? I have jurisdictional suggestions, legislative suggestions, and constitutional suggestions. And not necessarily in this order, because actually I think the jurisdictional ones are the most difficult. But nonetheless, in terms of jurisdiction, I think murder laws should be constant across all states and provinces. I don't think that one should be tried for murder different in one state or one country than the other. I think that makes that treats, I don't know, people differently based on where they're born or where they commit their crime. And perhaps it might even, you might be more likely to commit murder in one state versus another because the laws are different. Similarly, trying murder different across states creates for inequality of geography and complicates common law. For example, the Michigan Supreme Court case with the temporary insanity that could not necessarily be applied in New York because the murder laws are different. So it just really complicates common law, and then we're just going to have to accumulate more murder cases, which is unnecessary, and also would lead to more predictive behavior, just having constant laws. I think this is a James Madison quote from the Federalist Papers. The only refuge left for those who prophesy the downfall of the state government is the visionary supposition that the federal government may previously accumulate military force for the projects of ambition. So what I'm saying here is that by making murder legislation constant across all the states would not give more power to the federal government. In fact, I would even make the argument that I believe lowering the protection for the police officers will actually lower the risks of government tyranny. So I think this is obviously a more difficult one to implement, but I think this would be an ideal worth aiming for. In terms of legislative changes, I think this could be Congress and the House of Commons, because it is a problem in Canada too, should pass bills preventing unequal murder legislation while shutting down these clauses in Canada, New York, Hawaii, and Iowa. So I think they should fix the Canadian Criminal Code, shut down these laws, and essentially make it so, or some kind of perhaps bill that states that, for example, the Michigan law should be relevant in other jurisdictions. And I think now would be a good time, given recent police brutality, and furthermore to make this relevant to our class in terms of Kingdon agendas, alternatives, and public policies. I think one lesson from this book is that the president or prime minister does have the most power to do this. So if we were to go through the legislative route, we should really get the president on board and doing this. And as mentioned already, is already perhaps on the agenda. But furthermore, I think we need policy entrepreneurs to champion something like this. And then lastly, in terms of constitutional changes, and this is probably the last saving method. So appellate courts must revert to the 14th Amendment in the USA, which states, "Nor shall any state deny any person within its jurisdiction the equal protection of the laws." So as we see in these jurisdictions, that is not being held true. So perhaps a Supreme Court case should be found in one of these jurisdictions where they overturn the previous laws. Similarly, in the Canadian Charter of Rights and Freedoms, which is the equivalent of the American, well, it's entrenched in the Constitution, so it's the equivalent of the American Constitution. Every individual is equal before and under the law and has the right to equal protection and equal benefits. So I think both of these Supreme Courts should, and perhaps will in the history of time, find cases where these do need to be overturned. And I actually think this would be a very exciting Supreme Court case. Obviously, we wouldn't want more murder or anything of that sort, but nonetheless, I think it would be. So nonetheless, maybe not today, but ultimately, in the future, I think individuals will start to bear the costs of this legislation and unequal treatment under the law, from increased violence to unfair legal outcomes, and even the rhetoric alone, where police officers are seen as more valuable under the law, will lead to negative repercussions, and I believe they already have. But furthermore, we must normalize laws across states, provinces, and countries, but more importantly, people may need to accomplish this through the suggested jurisdictional, legislative, and constitutional suggestions. So I brought up this quote because we are, or most of us here are here in Pennsylvania, but we all go to the University of Pennsylvania, but it is by William Penn. It says, "People are more afraid of the laws of man than God, because the punishments seems to be nearest." So I think the main takeaway here is that firstly, not necessarily the God's as Thomas Paine shows in Common Sense, sometimes the laws can be contrary to morality or God or whatever you would like to call it, and sometimes the laws of this earth need to be changed, and sometimes they are quite bad. So we must strive to change this for the equality under the law and start treating police as people and manslaughter as manslaughter. So thank you very much. Any questions?
Great. Very interesting. So Soraya.
Kaylin. Thank you for your presentation. It actually was a very interesting topic. I do agree with a lot of the things that you were saying. I just was wondering, in your opinion, what do you think if manslaughter was just manslaughter, and if a civilian were to kill an officer, what do you think the differences would be in states that do have like stand your ground laws versus states that have like self-defense laws? Like, do you think that we'd have to have legislation that like wipes those out as well, or like what would that process be like?
Yeah, so as I mentioned, I think over time they should all be normalized or equalized. For example, even like the right to stand your ground or protection of property, if someone enters a different state and they don't know and the person has the right to kill them for entering their property, that's obviously a problem and might lead to unnecessary deaths. So once again, the confusion in these laws is creating negative repercussions. But to your question, how can we do this? Just overwrite them? I don't think it should be done overnight, but for example, this change could be done first. Then we can start addressing and normalizing those, picking out what's good in certain states and taking out what is bad.
With how we saw, follow up with how we saw like the backlash of like when Black Lives Matter started, and we saw a lot of like big movements for like Blue Lives Matter. Do you think this is something like the fight back from officers? I feel like the rallying they would do to not make this a law would be very big. Like, so how, like, do you think this is accomplishable?
I don't think there'd be any rallying because firstly, it's only these select jurisdictions. So if these jurisdictions wanted to protest, so be it. But I think they're fighting quite a losing battle if they think they deserve more protection under the law where no leader or no celebrity gets such a thing.
Okay, great. Sarah.
Hi, Caitlin. And you were talking about, I think, the president. I don't know if it was an example or not. Like, so a president getting protected. Are you saying that exists or it doesn't?
It does not. Like, I think I used the word. It would be absurd and it would be a moral crime. I think, yeah.
Okay. And my other question was also, what is your take on capital punishment?
That's a hard question. That's a really long question. I don't know. I guess I don't want to like. I guess that perhaps like we should avoid it at all costs.
Well, maybe in regards to this.
But
punishment.
Perhaps in the most crazy cases it could be possible. But we should really avoid it. Yeah.
Okay.
Okay. Nicole.
Hi, great presentation. In states where killing police is automatically first-degree murder, is it correct to assume the police would have to be on duty for this to apply? Like, I'm thinking back to Declan's presentation that gave examples of police that initiate violence off-duty.
That is true, but taking, for example, the Bad Elk case, the officer was actually off duty when he killed him, so I don't think necessarily, but I think in these jurisdictions I think it would be manslaughter if it was manslaughter if they were off duty. But if they are on duty and, for example, you're driving a car and you hit them, it definitely should not be first degree. Like if you accidentally kill them, yeah. But if they're off duty, to answer your question, no, should be fine.
Okay, let's see. Washik.
Hey, John. Also thought, I want to echo a great presentation. My question was, when going over solutions, you presented 3 points: jurisdiction, legislation, and constitution. Are those 3 points supposed to be considered separately, or are they in coordination with one another?
Well, I think all of them I think should be implemented. But I think some are more difficult than others. The first one, normalizing all murder laws, is obviously very difficult and will take perhaps even 100 years, even if done correctly. But the constitutional things, I think we could start reverting to the 14th Amendment more frequently in these jurisdictions. So that could be done tomorrow. I guess they're just different time frames, but simultaneously as well, if possible.
Thank you.
And let's see, last question for Kaylin is from Declan.
Hey, Kaylin. So I'm curious, my understanding of this is that in criminal law, the typical argument for the implementation of this kind of like elevation, right, of having first-degree murder, police officer, that's typically because of this argument for like a general deterrence effect. So there's this idea, you know, obviously that if you implement this, that there will be just this general deterrent, that people will not be inclined to commit violence against police officers. And so I can imagine that being one of the primary arguments against your proposal. So I'm just kind of curious, like, have you, in your research for this paper or this presentation, run into like any type of data or studies on the efficacy of those of that claim, and you know, the effectiveness of this I don't know if it's a statute or a specific rule, but you know, this elevation of this crime.
Yeah, well, I can just say based on look at Canada. Canada has lower murder rates, and they put all police officers in this elevated status, whereas we can look at states where they do not do this and they have higher murder rates. So that alone might prove that. But also, I think even if that is true, I think the moral crime of putting someone higher above the law is a higher cost. I think we should, like, you could say the same thing about the president, but I still think that would be morally wrong to put his life higher, even if it does lead deterrence.
Okay, great. Very nice job, Kaylin. Very interesting.
Thank you.
And proving my point, we have a wide spectrum of issues here. Okay, let's see. Nassim